Yes, give the memos. Give all the memos. Give. First, let it give. Yes, please give.
Item number 36.
Just wait. Let him collect. Yes.
Supreme Court remand matter, my lord, that is listed on today here as item number 36.
Yeah.
If possible, your lordship may take it today, or else may fix the date on 9th.
If we get the chance, definitely.
10th September, probably so that it will continue.
Sir, if the member of the bar restrict their argument to a point, I think that will be helpful to all of us.
9th or 10th September.
Let us see. Just remind, are you in hurry? You are here. Just remind us when the matter comes.
If there's so many dates, your lordship has listed it, but we cannot come up.
What can we?
Listing the matter in the top of
That's my incompetence that I could not reach. I have to be blamed for that. I will do it, sir. You see that the arguments are advanced so much of a small matter. What can I do?
Item 52, my lord. With object matter kindly taken up today's option matter.
Let us see. Inform the other side.
Already informed, my lord.
Inform the other side to be there. Just remind us before rising. Just remind.
Item 52.
Yes. Yes, give the memo. Yes. You have given a let it appear. It will appear. Don't worry. Yes, it will appear, sir. Why you are exhausting your energy for mentioning? We have accepted. Don't worry. It will be listed.
Item number 1.
My lord, if I may say, this is hopelessly barred by limitation. It's a
Yes, sir.
My lord, if I may say, my lord, I am appearing on behalf of the opposite party number 4 in order to save your lordship's time, my lord. Just a fleeter, I say that at the preliminary submission, my lord, that this is a January 2000 application rejected in January 2008, my lord, by the government, which is challenged before my lord. In the meantime, 2 rounds of legislative change happened in 2004 and 2016.
Sir, what do you want? You want an adjournment or you want
I'm appearing on behalf of the opposite party number 4.
That's true. Who is for the petitioner?
I'm only informing this on the court that this is a hopelessly barred by limitation.
Yes.
I will pass over on behalf of Mr. Naveen Kumar, your lordship.
Now he is asking for passover.
I can't do anything, my lord. I'm in your lordship's hand.
Actually, Miller, in this matter, the petitioner has challenged the virus of the statute, Miller.
Okay.
Just
Central or state?
State action.
My lord, for that, my lord, may I inform, to avoid the limitation, he challenged the virus of 2016, and similar challenges have been thwarted by almost, my lord, 2-3 high courts that to my notice, my lord. One is Andhra Pradesh High Court.
I understand, sir. I understand. But now the thing is that when the virus is challenged, the Advocate General has to be noticed. Is given. Have you given a notice to the Advocate General? Or do you have you waive this notice?
No, Miller. Advocate General will be appearing in this matter, Miller. So, maybe taken up.
So are you waiving the notice to the Advocate General? On his behalf, do you accept?
On his behalf, I'm accepting.
Yes. So when you can argue, because we have to decide once the virus is challenged, then we'll have to decide that virus.
Pleadings are not completed since.
Pleadings are not complete.
No, my lord. This is actually the first date.
The matter was dismissed in the difference admission stage. There was a review file restored on review, and it is coming up.
Review.
Yes.
Dismiss for default.
No, not on default.
I have 2 orders, Miller. That's it, my kindly.
My lord, the dismissed.
You like to complete the pleading?
Yes.
Now, at that time, pleadings were completed.
No, Miller.
No.
Yes, pleading. Is the virus of the
Rule 4 of
412.
Orissa Minor Mineral Concession Rules.
Rule 4 of the Odisha Minor Mineral Concession Rules 2016.
Rule 12.
May I, in the meantime, inform, if I may take, my lord, 30 seconds, if I may, my lord, if I may be permitted. In this matter, my lord, actually, the similar challenges are already thwarted.
Sir, definitely you argue the matter. You argue the matter, and it will come. Don't worry about it. We'll see to it.
My lords. So,
Item number 2.
This is just for opposite party number 4.
May I please? May I please? So, in the release of the security amount.
Yes, why you are not releasing the security amount, sir? When everything has been done successfully, the period, that the liability period has also expired.
This is fresh matter. Fresh matter.
This matter.
Another
this
one.
matter. Absolutely.
Yes,
I need to take instruction, not action.
2 weeks to take instruction.
Item number 3.
These are necessary. This is the day.
What is this contempt?
Actually,
Contempt is against the order of the contempt petition.
This is the appeal against the order passed in a contempt matter.
Contempt.
Who are you? Contemner or the petitioner?
I am complainer.
Petitioner.
It's the Honorable High Court, High Day Annexure 2, directed the
Just give me the contempt of court act.
reality agree. If it is adversely.
Section 9. Yes,
I challenge the order of annexure 5.
annexure.
Annexure 5. NCT. That is the Honorable.
Order in IA. Order in IA to revive the contempt petition which was disposed of in 2023.
Where is the order of 11/8/23? Where is the order of 11/8/23?
It is in the contempt petition. It is.
So according to you, it's not required to be annexed to the appeal.
Let's say this IA was disposed of along with.
Sir, we are on a different issue. We are on the maintainability of an appeal against an interlocutory order. We just wanted to know that what was the main order? Where is the order of 11th of August 2023?
My lord, 811 order is in the IA, which has been dismissed by the single bench.
Sir, are you not, because I tell you very frankly, why? You have to satisfy the maintainability of an appeal before the division bench against an order passed on an interlocutory application. You are not challenging the parent order by which you felt aggrieved. You are challenging an interlocutory order. Whether in appeal against the interlocutory order passed in a contempt petition lie to the division bench by virtue of section 19 of the Contempt of Courts Act is the first question.
Only I want to visualize your lordship Annexure 5, that order dated 11/7/2024. You lordship may go through this order, page 18. What is
Mr. Nayak,
Probably, I cannot percolate my question properly.
Mr. Nayak, my lord desires to know whether this contempt appeal under section 19 is maintainable when you have challenged an order passed in IA, which is filed for revival of contempt petition, which was disposed of in 2023. And are you coming within the fold of section 19? That is the whole.
My lord, that is not the point. Point means the.
That is what we've considered to be a point.
My lord.
Then what is the role of the member of the bar? Even if the bench has a very, I would say, very irrelevant point, but it is a duty of the member of the bar to eradicate any confusion which has arisen in the bench. The member of the bar cannot straightaway reject that particular query of the bench that it is not relevant, because you have to satisfy that it is relevant or it is not relevant. We are still open. If you satisfy us, it is not relevant, we will proceed, no difficulty.
Two cases were rejected by the single judge. Two cases. One is the contempt petition and another the IA arising out of a contempt petition. Your lordship in order dated 11/7/2004.
That is why it is projected to you or impressed upon you that in absence of challenging the 2023 order in this appeal, can you maintain this appeal against an order passed in IA to revive contempt?
What is the source of power to file IA? Let us go into a very rudimentary principles of law. What was the provisions under which you filed an IA? Tell me. Let us go to elementary principles. Let us see. Can you tell me under what provision you can file IA in a disposed of matter? Tell me.
Liberty was granted when the.
I am again asking you, filing of an IA is an important factor. What was the provision you invoked to file IA in a disposed of matter? The content was disposed of. Tell me, what could be the provision? Under there must be a provision in which you can file an application.
Contempt petition, contempt is a matter which is the power of the court to so much also draw the.
Correct. Then who are you who can come? You are simply an informant, whether your right to appeal is there or it is only a matter between a contemner and the court, then it's only the contemner who has a right to file an appeal. I accept your argument. Then my argument is this. What you have to say? That petitioner is merely an informant. Nothing more than that. Now matter is between court and the contemner. Then who can file an appeal? Is the contemner or somebody else?
When the honorable court did not know about the negligence.
Sir, I understand. That is why I say you are not challenging the parent order which is passed by the court in a contempt petition. You are challenging an order passed on an IA filed in a disposed of contempt petition. First and foremost point which struck us that whether IA is maintainable. If it is maintainable, then under what provision it is maintainable? If it is-
Permit me some time.
Definitely, this is what we wanted to say, sir. And whether the appeal against an interlocutory order would lie.
Permit me some time.
How much time you require, sir?
Lordship may allow 15 days time.
15 days time. You want more? We can give you more.
I think.
15 days time.
Yes.
That very fixed me. That
I think
It is up to you. When you can get yourself ready for this point, tell us any date. We are ready to hear. Tell us the date.
I explained the question.
Come.
Item number 4.
Hmm.
My lord, the senior advocate, Mr. B.P. Tripathi is occupied otherwise and he will not be able to attend the court.
you want adjournment. You want adjournment.
Yeah, adjournment. Yes. Right.
Serious issue.
Regarding this issue, today I have received the instruction from the head of the department, nephrology department. So I'll put it by an affidavit. Your lordship may call it next week or any day.
Another case is also.
Let them file an affidavit showing the disclosure.
Yes.
My lord,
The public interest litigation is filed by the petitioner.
Like in identical matter, your lordship has not granted any model. It's where the one bidder was selected in 10 matches, 10 tender, but he choose to select in accept 2. I am saying the condition provides, including next 2 years will be banned, including this. Your lordship observe that it will be prospective. That issue only notice was issued and process may go on. But no final. It's a municipality matter, same notice. The same notice, different purpose.
Yes, what you say. Have you gone through that? Is the same matter?
This tender is quoted by municipality.
Lordship, same.
Oh, that's true.
Notice to go to municipality.
Yes, same. It is
Yes,
same notice.
same notice. They are opposite party number 4 and 5.
Same opposite party. Same notice, the arrangement.
Yes.
Item 6.
Item 6 may I present. In this case, the presentation file is recommendation, the lordship regarding illegal transportation of minor minerals. That is under another one. But that recommendation is still pending. My limited prayer with the lordship may direct the appellate but not to consider. Let him decide.
Bad bench.
Lordship.
Bad bench. You have chosen
That is still pending.
wrong person, sir. You have chosen. At least my view is very clear that I do not encourage this kind of a concept of passing an order to consider representation so that another litigation is already forthcoming. Tell me what is your right. Tell me, I will decide here and now what to do and what not to do. Tell me.
The presentation of lordship can have a glance based on the lordship.
Yes.
He made it to.
First thing is, who are you? What is your locus?
I am the citizen of that
Locality. Can you maintain a writ of mandamus? Or if you want a public interest, whether it comes within the public interest.
That is public interest admitted.
You are not asking for a public interest litigation. Can you maintain a mandamus?
May request lordship, state consulment directed to take instruction in this regard.
I have an answer for this. I do not want to use that word.
Liberty will granted to file a case.
What is this? The complaint is lodged with you and flagging an issue that there is illegal mining activities.
2 times complaint was lodged. One is on 27/10/2024 and another one is 25/3/2025.
Disclose the steps having taken here and now, otherwise we'll direct issue a mandamus on you to do it. Yes, the instant we are not going into the locus, but you have a difficult time.
Item 7.
We filed the amendment petition, the lordship.
What you want to incorporate? What do you want to incorporate, sir?
We filed a compulsory petition.
Certain mistakes you want to correct.
Already filed.
That does not mean it has to be allowed. You may have filed it.
The right of-
I just wanted to know, you have to say that what amendment you wanted to bring.
Your lordship, the rate of interest, equal to the petitioner, was wrongly mentioned as 34.
See, that's why you wanted to have the typographical error to be corrected by way of an amendment. This is, it is one line is enough for that. Yes, it's a very innocuous application.
No copy has been served, my lord.
Please serve him a copy here and now. Serve him a copy. Do you have an extra copy?
I'll serve it within, during the course of the.
This is an application for amendment of the writ petition.
Item number 8.
Actually, this petition was filed regarding the inaction of the state government in making the state consumer commission defunct by not appointing a single stenographer. In the meantime, the commission has itself engaged some persons on outsourcing basis. We will withdraw the petition with a liberty. to file.
No, one thing. Is it a sanctioned post or it is a non-sanctioned post?
Sanctioned statutory post. Sanctioned post as per
Statutory post can't be.
sanctioned post of stenographer.
Stenographer is not a statutory post.
Sanctioned post.
Why you will not initiate a process of deployment or a engagement or a recruitment of this stenographer?
For press recruitment, steps have already been taken, my lord. They are in the
Because
process.
the stopgap measure is maybe a temporary in nature, but there should be a permanent deployment of.
Well, it will be with today's instruction, you know.
Since January 25, it is like this defunct.
That's why you were withdrawing, but we do not permit you to withdraw because we wanted these things to come.
Indeed, Your
So tell me,
Yes.
I wanted you when I get this opportunity. Is there any instruction
Yes, lord.
issued by the state
Yes, your
that please happy.
I'm sorry. I'm sorry.
I'm just framing a question.
I'm sorry.
Is it a stand taken by the state that whenever any recruitment process to fill up the sanction post is about to be undertaken, the permission from the finance department or a permission from the other department are necessary?
Yes,
Why?
because your lordship,
Why?
look at the rules of business. In the rules of business, 10A, your lordship may. That is framed under Article 166 of the Constitution of India. That rules of business.
This is not against the normal functioning of the government. Because what I feel is that, yes, it is within the domain of the government to sanction a post. How many posts are required in a particular department is the wisdom of the government to decide. It requires a concurrence of this finance also.
Yes.
It requires a concurrence of the other officials as well. Once the government decided and the finance department also agreed and approved that this much of posts are sanctioned required. So these are the sanctioned posts. Then the recruitment to the sanctioned posts, does it require every time the concurrence of the finance? No. I have come across recently that there is one GO which is issued by the government that for filling up that sanctioned post, further concurrence of the finance is required. It's unknown to me. It's unknown to me. It of it. But there has been some kind of a spanner in the recruitment process concerning the sanctioned post and the visualize. That I will talk to you. That's is this what you have done?
In this case, as soon as we received the proposal from the commission, the Lordship may kindly see Annexure A. Immediately an approval was granted and the commission was requested to give appointment against those sanctioned posts for immediate requirement through outsourcing basis. And in today's instruction, they have stated that requirement, they have intimated the commission to give appointment through outsourcing basis to meet the immediate requirement. And so far as recruitment against those sanctioned vacant post is concerned, steps are being taken. That is what is stated in the affidavit.
I just wanted to know that whose responsibility is
the
whether the
department.
chairman of the state commission has to initiate a proceeding being an appointing authority, or the government has to.
It is the administrative department who has to move a requisition to the state commission, the recruiting commission, to because these are all stenographers. So Odisha Staff Selection Commission.
Can you transfer any stenographer from a commission to another department of the government? In
Regarding that, I'll have to cannot from the commission.
Sir, fourth line. And sir, a fourth
no,
line.
no, that is, he said if the retired person you take as a stock of measure. No, it is not in some things. He's saying that it is the recruitment by the department. I say that once you recruit somebody in the commission, can you transfer him in any other department, or the department?
Cannot.
So it will be the recruiting power must be given to a chairman of the commission.
What they have stated that as soon as the proposal regarding regular recruitment is received from the commission, they will do it.
Why? It is the commission who has to start the process because it is the sanctioned post of the stenographer. This is what I am flagging, why I asked this question to you, because yesterday it came to my notice. I just wanted a stand of the government on in this regard. You are talking about the deployment of the retired person.
That is only to meet the immediate
Temporary measure, I
Yes,
understand.
yes.
It's a temporary measure that
because the recruitment process will take some time.
the chairman is also a retired. The commission is who has or has been the judge of a high court.
Now there is even no regular chairman and officiating president system. That post is
You are not the filling of the post of.
Line vacant.
And also.
Some matters are pending before the Supreme Court.
Consumer Protection Act. I don't think so. I think he has some different ideas. He is a different, not.
Yes. There are
Oh, that is,
they are
I'm sorry. Yes.
Nothing.
there was some problem of certain time.
Fine.
GST update tribunal.
What to do?
Lordship may grant me some time so that I can write the opposition.
My view is that
I just expressing its tentative view. No, I observed this. My view is that when there is a sanction post and which failed vacated, then there should be a regular requirement to set sanction. This temporary measures, retired employees being put there, it is not really, that will not augment the seamless functioning of the person, because you don't know. These retired people sometimes, because of the health issues, because of some other reasons, because it's there are many factors that may come into. This is what I really wanted to do. I wanted that because what is the recruitment process for this staff? Is done by the department or the power is given upon the chairman of the commission to initiate a process for filling up the post?
Power is given to the state government under section 46 of the Consumer Protection Act.
To appoint?
To appoint such officers and other employees as it deems fit, thinks fit.
Okay. So this is the state you have.
Yes, but
Then we are passing, sure.
Section 46. Oh, yeah. Old rule continues.
only one, your lordship may pass that order. I'll just.
Not going to affect.
No, I'm not obstructing. Only I'm saying, my lord, he has filed this PIL in the nature of PIL, but he has raised private concerns because his appeal is pending before the commission, which is not being taken up by the commission because of no steno is available. That is what is raised in this.
Yes.
My lord, that I just informed the whole court that is being raised.
The again because it says about the retard, we preferably say that the movement of the base also, including the chair. They have to do. Right.
Item number 9.
In this matter, we humbly pray for 7 days time to file our affidavit order. That is a matter relating to technical glitch, Miller. And we have ensured that tender process is not proceeding further in the meantime.
What if you trying to fix the deed? The friend can come up with the instruction.
Because we have a short process allows the NIC to there is no
But you know, the FCI workers union before the concept challenging a tender process.
As a trade union or like
Trade unions.
registered.
Registered. I have given the details also.
Yes.
Lord,
Yes, sir.
if your lordships, before I come to the Lord.
What for you have crossed?
Yes,
Engagement of handling laborers.
yes, because this was being done by departmental workers. Yes. It was done by departmental workers. What now the FCI is following is a one labor system. Either there will be departmental in a particular depot or the contract workers. To that extent, my lord, since all the depots were under the Section 10 notification under the Contract Labor Act where prohibition was there, from time to time, denotification or like giving them the liberty under Section 31 to engage is being issued. So that the last was being issued in 2025, which I have, my lord, annexed at page 39, if you'll also see. Which is part of the annexure, my lord, 2 series. I have given 3 notification. 39. Where the exemption notification has been issued. That is dated 14 July 2025. And this depot, the employees for which, my lord, and for your lordships and on behalf of the union, has not been mentioned in that, which is the Khurda depot. And if your lordships would see the reason why it has not been. I'm sorry, my lord. No, my lord, thereafter also. Thereafter also there is another one. That is Kesinga, Dhenkanal, Jharsuguda, Rapsa. Then, my lord, on the next page at 93.
30.
Yes, my lord. Item that is, my lord, 30. Then 93
Is Burbill.
is Burbill. Then, my lords, on the next page again at 130
Is
Burger.
To the burger.
Yes, my lord. Then 144 is Keonjhar. My lord, that's all. So these have been exempted from engaging contract labors. They can. But here, this Khurda was not included
Was the contract laborers were engaged?
earlier. No, never been.
They were never engaged.
They were never engaged.
Why you wanted a contractual laborers?
No, my lord, I am for the union. The management has now come up with this, my lord, tender to engage contract
How
laborers.
can it be? The exemption has not been granted.
Not
By
granted.
this
And my lord, the reason why Khurda, just one more issue, where there is a settlement since 73, where Khurda depot has been included to say that here only departmental laborers can be engaged. And for the same set of work, now they have given the notice, like the tender has been issued for engagement of contract labor.
My lords. First of all, my lord, section 10 of the Contract Labor Abolition and Regulation Act says, and I'm placing that section, prohibition of employment of contract labor. Notwithstanding anything contained in this act, the appropriate government may, after consultation with the central board, or as the case may be, a state board, prohibit by notification in the official gazette employment of contract labor in any process, operation, or work in any establishment. This depot that is now under consideration was never a prohibited depot. There is no notification which prohibits deployment of contract labor in the Khurda.
Those who have
No, my lord.
been excluded
My
in
lords.
15 July.
That is an exemption notification.
Whether there was any prohibitory
It
notification.
is there, my lord, I have given the detail. And
Let's look up point, right?
no, my lord, I'm just,
Look up your brief on that.
I'm sorry, my lord, because I
Is there any
just.
prohibitory notification issues under 15
Yes, ma'am. A list of 226 depots.
But
I am appearing in
these
this.
were the depots,
My lord.
there was a prohibitory notification that they cannot engage.
This is a list, my lord, sir. Because I am appearing on instructions, I still have to be served a copy of the
What
report.
is nature of our instruction, sir? You can't
My lord.
go out of it.
That's the list of the depots. Now, my lords will, under section 31, my lords will see that.
Just for me.
My lord. My lords.
So if there is only a prohibition under section 10, then section 31 comes into play. My lord, may kindly take section.
Look at the provision of section 30.
My lord.
These come. Let us read together.
My 31, my lords.
Yeah.
Part to exempt in special cases. The appropriate government may, in the case of an emergency, direct by notification in the official gazette that subject to such conditions and restrictions, if any, and for such period or periods as may be specified in the notification, all or any of the provisions of this act or the rules made thereunder shall not apply to any establishment or class of establishments or any class of contract.
That it is only referable to section 10.
Any provision in the contract labor, entire act, including section 10.
Provision of the act of the rules means in its entirety, everything has been.
My lord, so that includes
It may include the other obligations, the grant of license,
my lord,
the revocation of license.
My lord.
These are all also can be exempted from.
my lord,
So it is more omnibus.
my lord,
There's a restrictive one.
my lord.
So you can't say it is only referable to section 2.
What I'm saying, what I'm trying to.
Now we got your point. You say that unless the establishment is duly notified by the notification issued under section 10, he is automatically exempted from the purview of this act. This is what I understood you wanted to say. And once it is outside the purview of the act, then any action which is taken cannot come within. I got your point of the day one.
What I'm also trying to impress upon my lords is that section 31, the list that has been annexed, the list of exempted depots that has been annexed to the writ petition.
Yes.
That list of exempted depots comes into play only when there is a prohibition of contract labor.
Oh, I understand, sir. I understood the moment you say. You did not have to elaborate. Let us see whether this Khurda was coming within the
another
thereof.
A copy of
That is why I said, my lord, I'll just take the lordships to another document at page 50.
50.
50 of the writ petition.
Yes.
So lordships would come, this is a settlement which was between the management and the workers union at the national level, where the departmentalization of the employees was not agreed upon in 1973 after the 70 Act came into the picture.
Right.
If your lordships would come to Lord, the paragraph 1 on that page 50, my lords.
Departmentalization. Yes.
Management agreed to introduce departmentalization. In that, my lord, if your lordships would come to
depots owned by the food corporation.
yes, if your lordships would
be there.
Orissa is there, page 2, including Khurda. So that is the reason why there was no specific notification was issued vis-a-vis this. But now, so far as if they say that without disturbing the departmental employees, they want to bring in somebody, we don't have any problem. But what they are following the procedure which has been.
No. If the departmental employees are the regular employees.
Regular employees.
They cannot be removed.
No, but what they are doing is. Yes, what they are doing, which has
perennial or a vested right into the depot.
Yes. So what they are doing now is, my lord, which also happened in West Bengal.
Yes.
Yes. My lord, what happened in West Bengal is also the same thing they introduced. They said, we will lock, stock, barrel, shift from here to X place, another depot, and introduce the system there, which has been stayed by the Honorable Calcutta High Court. I'll just, the lordships want, because that is also regarding the FCI. There are also similar, my lord, tender were floated in 2022. And if your lordships would come to page 2, what they submitted. So what they are doing is lock, stock, barrel, whoever is here, since they have said one labor policy.
Then
So
you'll have to satisfy the court that if it is a transfer policy, there is no
No.
jurisdiction of the rate court.
no, my lord, they don't have any transfer policy as such.
Once there is no transfer policy, if the organization or the institution or the department, they decided to transfer. Unless you know there's a chapter.
No, my lord, they have not yet issued any transfer order, but that is what they have been following in different, without any policy.
Then on presupposition, you can't come forward. If it does not come within the purview, without
If they
affecting
don't-
the regular appointees, then
No, then absolutely we have no problem.
There to be.
That, no, my lord, if they are not disturbed or they are not
They
adversely
cannot-
affected.
They cannot say that I have a perennial
No,
right
no, my lord.
to remain in a particular depot when the transfer is an incident of service.
No,
You
no, my
can
lord.
transfer from one depot to another.
No, my lord, in FCI normally, there is no transfer, inter-depot transfer policy in the workers
There
level.
cannot be a transfer policy.
My lord, workers,
To create a statute, it creates a more hurdle and more difficult times.
my lord, what practice they follow is normally departmental employees, if there is a short requirement at a place, they take some people temporarily, then bring back. But there is no transfer of the workers because they are class 4 employees. They are engaged in a particular depot, appointed and retired there. That is everywhere. In all FCI depots, it is not confined to Khurda only. But intermittently, there is, let's say there is a shortfall or there is a higher procurement in a particular zone. For a short period, they sift them and then bring back. So that is what they follow. But what they wanted is also in the Bengal, this thing, where they have admitted in their counter. Well, unfortunately, I could not get the copy of the counter. I'll get it. That is was my instruction. They said that we will lock, stock, barrel. We take it to other place and the contract labor is introduced here.
What was the conditions of service at the time of an employment in the food corporation? But it is a non-transferable post.
In depot for the class 4 employees.
I do not know
Well,
whether the service condition it provides that it is non-transferable. Then in that event, they cannot change the rules or the service conditions subsequent thereto. That we understood. But I do not think that their appointment letter talks about the same.
Because they are governed by the certified standing orders now, because they're class 4 handling labors. And these are the certified standing orders. May I kindly have a look at clause number 5.
What?
The certified standing orders.
What says?
Let's transfer. The CSO, the certified standing order clause 5 is transfer says the worker shall be liable to be transferred from one place of work to another place of work of the corporation as per practice in existence with the whole gang, except in the case of request for transfer of the individual.
Except for the request for transfer.
Of
From individual.
Individual.
So the whole gang will be transferred.
That is what
It's there.
So that is what they are, in a circuitous way, when the settlement is there, they are now bringing in the contract labor system here.
They have not filed your affidavit.
I will
Let
file.
them. Let them file the rest.
That's okay. The
We are trying our
I am requesting the Lordship that I may permit to withdraw the writ application with the liberty to file a fresh one, because that document once it is, it is a part of the record, many things have to be again amended, because that has to be challenged, that in prayer, that has to be prayed for quashing, all these things. So, my lord, with the liberty to file a fresh one, your Lordship may kindly permit me to withdraw this.
The dates of the petition contains to application. Because you mentioned. And case of withdrawal of the sake, the liberty to file a fresh. Solution of the amendments and the submission to the source. The liberty to file a fresh.
Item number 15.
Instruction law.
One adjournment matter, because my senior was here, but due to some personal difficulty, he has to run.
Item 16.
I'm telling the order on answer 1 minute. But when the Lord Commissioner deciding the appeal has obtained the order of penalty under section 10 capital A of the Central Sales Tax Act. The petitioner is a cable network service provider having a registration given by the Government of India. What has happened for operating that, the petitioner has obtained set-top boxes and cable from a registered dealer from New Delhi. It made some interstate purchase. While purchasing, he has given C form for purchasing these goods. Admittedly, those goods are the goods I have been registered to be dealing with. That's undisputed. Another undisputed fact is that after purchasing those set-top boxes and cables, I have supplied those materials to the customers who are availing my services.
Have you charged for?
That's the allegation. Now this proceeding has been initiated saying that you have not charged tax while supplying those materials.
That's true. That's the main important. That's why I asked you this question.
Yes, ma'am. That for being, I'll that point of time, whether it will be a tax supply or sale, those things are apart. Those things apart, even if I have not charged for mere non-charging of VAT,
if it is a chargeable one, if the goods attracts any kind of a sales tax to be imposed, if you do not charge, it is immaterial. Yeah,
if I don't charge VAT, then the VAT tax takes care of it. I can be proceeded against. Now here, what has happened? They have proceeded against me under.
The set-top box.
Yes.
Or already difference. To purchase it by using C form at concessional rate from outside the state. Instead of reselling it, you have made what?
I have supplied it to the customers.
Customers.
That's
So
on
not by way of resale.
That's the allegation.
Or transfer of right to use. Or any other. That's all. Coming within the fold of definition of sale. Right?
Yes, but essentially it will be a transfer of right to use.
So other than by way of resale or sale, if you use the goods after availing the concession, so they have imposed penalty under section 10E.
But in my mind, the submission is that supply of goods to the customers, that essentially is transfer of right to use the goods. Now, in a proceeding under section 10 AML, it is a imposition of penalty in lieu of
The
prosecution.
point is, transfer of right to use also as sale. So it has to be construed as good as resale. So you have not violated the conditions of C form.
Yes, madam.
That is your
That,
point.
and my lord, the requirement, you will also know, since it's a penalty in lieu of prosecution, the requirement is so high, my lord, there has to be certain deliberate attempt on my part. Willful attempt. Since it's a penalty in lieu of prosecution, my lord, there has to be a willful. Because of all these things, my lord, he has supplied it. So that's how, my lord, and without none of the authorities have gone to that aspect of deliberate, whether there has been a deliberate.
Section 10 found guilty was at any time proceeded with.
None of the authorities have gone to that aspect, whether there has been a
Section 10.
10A capital A that requirement.
Have they proceeded first to found your action guilty?
No, madam, that's what my
Under section 10.
10D. madam.
So that compounding of offense or
Yes,
penalty.
yes,
10A.
yes. But they have not.
They have not.
Not. By mere by
Notice must have been given.
yes, madam, notice also
Under section 10.
under section 10 without mentioning whether it's 10B or 10D. Without mentioning any particular section, madam, they have given that notice.
Is it necessary to quote the section?
No, not to quote the section, madam. Under which of those subsections I fault there is a judgment also of our Honorable High Court. Unless you specify the specific.
They have said section 10 clause D.
It is in the order, madam. It was not there in the so-called, which was a requirement on without that.
If the offense or the violation is contemplated under D, and if there is a specifically narration is there, does it mean that we are non-quoting of subclause D will it invalidate everything?
I'm what I beg to submit, my lord. Since the requirement is that there should be a deliberate.
We need to see this.
Madam, kindly see section 10. Look at it. In capital A. May I place on. The heading is imposition of penalty in lieu of prosecution.
Yes.
If any person purchasing goods.
Just one.
section 10 capital A. The allegation here is that 10D I have violated. Kindly see 10 small t.
I see.
I'll just highlight two words. If any person placing section 10
Any of a use of the goods for any such purposes.
without reasonable excuse. Requirement without reasonable excuse, and that has been interpreted by our Honorable High Court, by the Honorable Supreme Court in many cases, that there has to be a
Plausible explanation.
plausible explanation. There has to be the department, in order to levy such penalty, it has to establish certain deliberate defiance of law on my part. That's the requirement. I will place those judgments. Then section 10 small t refers to 8.3b. So if you violate 8.3b,
I have also gone through 8.3b.
8.3b, among other things, it says, after purchasing the goods has been intended for resale.
Correct.
So even if it doesn't intend, I must at the time of purchase I must intend it for reselling. That's the requirement, madam. Now kindly see in my facts, madam. After purchasing those goods, madam, I have gone to the department with the invoice asking for the C form. Now the C form has been granted. Now undisputedly, all the authorities have held that I have supplied those goods to the customers, madam. So it has changed hands, and the transfer of the right to use the goods, madam. So I ask myself, whether this constitutes a deliberate defiance on me, on my part or not. Without examining that, the department is directly.
8.3 you cannot segregate it. Now by way of an amendment, the telecommunication has also been used.
Yes, ma'am. That
Is the use of the materials, sir. Everybody has a common experience in this regard. The network provider is what he does. And comes and give a set-top box. How he gives and what he takes.
and at that point of time, my lord, whether it will constitute a sale or service, that question will
Working
also there.
technical on the point. The hard realities is something different. Hard realities is something different.
But here, my lord, the department, in order to levy the penalty in view of these,
Previous 1 week.
17.
certainly intermediate.
And continue with the recovery.
That would prejudice me, my lord. Kindly see.
If you want, we can record, otherwise we are not.
Right?
Yes.
My lord, may directly to pay certain percentage, my lord, otherwise this will prejudice, and I will be prejudiced, my lord. But kindly see, without.
If you say then we are recording it, that all payments will be without prejudice to the.
Directly to pay certain percentage of that, my lord, in view of this, my lord.
Item note 17.
See, my lord, 73(4)(3) of the Finance Act.
Yes.
Item 18.
Item 18, Your Lordship, may I please? I'm on VC. This is an absence of the tribunal, Your Lordship. This is regarding 1010 matter.
No, what?
Call him.
Sorry. 17.
Yes.
Item 18.
Item 18, Your Lordship, may I please? This is an absence of the tribunal, Your Lordship, 1010 matter.
Yes. Item 19.
Obliged.
The forward matter relating to GST cancel. Question, please. You will find it. No, no, sir. That's not so. You are not giving it to you. Think of themselves.
I have checked it,
check.
but your lordship may kindly look into the date of volume. If he is ready to deposit from 2019 till 2025, whether he is interested to do the business. From 19 to 25, no deposit. As your lordship, please. I should not object, but since it is so much,
You should take one time.
your lordship. Since it is 2019, I am objecting.
Item note 20.
This matter relates to cancellation.
I am verifying the matter.
Item 21.
Yes.
Item 22.
So Lordship, remember that case where both the petitioner as well as another person, they were involved in a criminal case. Both of them were acquitted. The other person being a regular employee, he was reinstated, whereas the petitioner being a temporary employee, he was not reinstated. So he approached the Honorable Single Judge.
There was something which was told
Yes,
to you.
it has been done, man. It has been. The order passed by the authority, that is enclosed. That order is also enclosed.
Re-engagement has been served. Right.
Yes. Item 23.
ये रिकैपिंग जो है मेरे पिटिशन मेरे पर्सन हूँ और आप थोड़े हिंदी में सबमिट करना चाहते
Is the advocate which is already there.
सबमिट के वजह से मैं हाजिर करूँगा इनको
What? Have you revoked the Mohammed Ramanan? Have you selected the Mohammed Ramanan?
मैंने भी दिया था लेकिन मैं फिर सोचा मैं पर्सनल आर्ग्यू करूँ मुझे
No. But you can whatever you revoke the Mohammed Ramanan. Oh. Yes, whatever.
नहीं वो ऑब्जेक्शन है विंडोज समय आर्टिक के आगे देंगे से बात से ये जो नहीं
No, then you have to.
पर्सनल आर्ग्यू कर लो हूँ पर्सनल कहबी सिंपैथेटिकली तो उसके लिए क्या आगे देना पड़ेगा?
He is 5%. No. Well, I was just looking at the player.
नहीं,
No, no. The local people are advocate the side, I have seen that. That's why I'm asking.
Office solution person.
Up to page 13 left.
No.
And by the end,
उसने जो मेमो दिया था उसके रिगार्डिंग का मेमो दिया था मैं इन पर्सन कॉल
इन पर्सन ऐसे नहीं होता है जब आप और बयर को जब आपने इंगेज किया तो बयर को आपको तो पहले उससे पावर को खत्म करना पड़ेगा, नो ऑब्जेक्शन लगे नहीं तो उसका लिख के लाइए कि हमने आपको पावर दे दिया वापस, ऐसे आगे खड़ा होने में नहीं होगा, क्यों दिए उसको पावर? जब दिया था तो इसका मतलब नहीं है एक टाइम में आप आओगे, एक टाइम में वो आएंगे, फिर आप आओगे, रिमूव करके आइए। कानून के अंदर में है कि पहले आपको पावर को कैंसिल करना पड़ेगा, रद्द करना पड़ेगा।
मेमो दिया था
मेमो देने से नहीं होगा, लॉयर का सही चाहिए। So please do that. You have to do, otherwise you can't. Take one signature from him on the Mokalatama that I am returning it, no objection.
I'm common there. Can you give us thought?
When? Second?
Second. Item 24. 2nd September. Item 24.
But here in the CETA appeal, I have come up against the judgment passed by the learned single judge, dated 26/2025. The salient features of the case is this. These two petitioners, they were exploited by the State Bank of India. First, initially, what happened? Their entry into the service so far as temporary daily wages or daily messages, submenial staff. They belong to the employee of the State Bank of India. In government, that is different. So far as bank is concerned, a employee has to be under matriculate, to be a class 4 employee, submenial staff. This is the basic educational qualification. They come up with the necessity of the workload to the notice board. They do a selection and they give these persons on NMR or daily wages basis. That time, I'm talking about for 30 years back, when they were initially appointed on consolidated wages, on wages basis. During that period, there was a bipartite settlement between the bank, the State Bank of Employees Federation, and the Employees Association that these persons in 86, 97, like this, there were various settlements. Last settlement ended in the year 1997, that the panel will be there after the, in terms of the PRSing judgment, you lost it knows, because 92 Supreme Court PRSing was that time governing the field. Not Umar Devi had not come into existence. So therefore, those persons who had completed 5 years of service, they will be considered for the post of a class 4 post for regularization. So this panel, time to time, was getting exhausted. And these persons were appointed in the year 1990. So when they continued in the bank, a person who continues for 240 days regularly, he is first entitled for a temporary status or a temporary pay. That is, which constitutes a basic pay, consolidated pay with HRA, ESI, Provident Fund, other benefits are provided. So these persons, they work continuously. But
they were not given the temporary pay because there were two kinds of pay scale in the bank. One is a temporary pay, another is your permanent workman who is entitled for a regular pay. So when they were exploited in the year after putting in 5 years of service in terms of harassing, we came up before this honorable court in ODC number 13193 of 99 seeking for a regularization of service. There that the honorable court, after keeping the matter pending, hearing both the sides for after 8 years, it was ultimately disposed of in the year 2008 with the direction that there shall be regularized. But what happened in the interim? What happened? We were so exploited that even the minimum wages was also not paid to us. So therefore, they said they shall be paid at the rate of minimum wages. Because temporary pay is higher than the minimum wages, which is paid to a temporary employee. But since we are basically employed on daily wages basis, we should have got our daily wages initially. Thereafter, they gave us the temporary sweeping charges. Those annexures also I have annexed everything, including the lower court records, some records which were available to me but which were not legible. Those also I have got it. I'll file it before your lordships by way of affidavit. So they shall be regularized. But no regularization took place. Then after completion of 10 years, in between Umadevi case came in the year 2006, as your lordship knows, that we are employed since 1994. So we had completed 10 years of service. And in terms of harassing also, we are allowed to continue. So this court directed for regularization and they shall not be substituted with fresh hands. If there is a work, they shall be allowed to continue. There was a conditional order. If there is a work, if there is no work, the authorities get retrenches. So therefore, that is not amounts to a stay order directly from this court. It's an indirect method that if there is work, they will continue. If not, they will go. When we continued for around 10 years, we filed another writ. That was in the year 2008, WPC number 8906. That also I have given. There my prayer was that we should be considered for appointment, taking into consideration my long tenure of service in accordance with law. That either you come up with through advertisement or through whatever procedure. That was also because they were not going ahead with any recruitment. There, that court ballots, this writ was also disposed of with a direction that we will be considered if any appointment is made in the future, then taking into consideration the long length of service, our case should be considered for appointment. Then, my lords, it lingered on. They exploited us. They kept us paying us a temporary sweeping charges, but that was much less than even what is given to a temporary employee, submenial staff or a sub-staff of the bank. There is a class 4 employee which they are engaged in sweeping. These are safai walas or sweepers or whatever the designation is that they are sweepers. Now, when they were not regularized, they went for outsourcing work. So for outsourcing, when they went in for outsourcing, we had filed the petition that they are going ahead with outsourcing, they may terminate us. So taking into account the length of service, we may be allowed to continue. And if appointment is made in the meantime, we will be considered. That was an order from this, 2 orders of this honorable. Then when they did not regularize us, in between one Bijay Kumar Panda was regularized in service. There also the stand was taken that he was a liftman. There was no sanctioned post. He does not fit in the educational qualification and others. As per Umadevi's criteria, the bank came up with their argument. That was countenanced by this CJIT. They said that he has to be regularized because he has also put in more than 10 years of service uninterruptedly. That CJIT judgment was carried before this honorable court, and this honorable court upheld the decision that they had to be regularized. The bank lost the case. Bank carried on an appeal on an SLP to the Honorable Apex Court. The Honorable Supreme Court also held that he should be regularized in service. They did not interfere because continuity in service by efflux of time.
Bank is to be noticed. The bank has appearing.
We have to notice as to go.
Let the notice, because these are the such a checkered history. Because it will, you are taking at least 20 minutes time to just complete the narration of the facts.
Right.
So it's better to give a notice so that let them come and.
Let
decide
them-
the matter.
But I wanted increased protection,
What
no,
did you-
no coercive action.
But there is-
Because the moment they have decided to proceed for termination. Because this is a regularization
That's
matter.
the thing which is coming out in that, because the protection has already been given in earlier matter.
That may be reflected. That may be reflected because
There.
if the my lords in
Because it was a case of a regularization which has been done.
there my lords the points are
The protection in the earlier writ petition is already there, where it says that you will not be disengaged.
but that is exactly my predicament. The moment they say 25 years will be made
If you
applicable.
come for disengagement, you come and renew the prayer for interim, you consider it. Just notice 2 weeks.
Right.
Short form.
And in the
Item
regularization
20.
matter, the corresponding matter is the regularization matter.
I understand.
That-
For the same.
So, and the points are also very clear also. Once the order has attained finality, you cannot
come, but notice immediately you file within the recruitments. So that it will go within 2 weeks. We are fixing this matter out.
Item 25. 25.
Say that if any kind of.
All of the things, sir, don't worry, if they disengage you, come with this 82, that whether it runs counter to the earlier order of the court.
25.
I didn't copy of that order.
55 matter, you let's say, probably hard on the last occasion, it was for order.
With the questions.
Yes. Then on council for OP number 7 to 27 or also by the half.
Okay, maybe. This leaking, give me the very instruction, the very simple. Taking, I mean, you will.
Right. 26.
I am in virtual mode. I am in virtual mode.
Who is for the petitioner?
I am for the petitioner, madam. For in virtual mode. Lordship, in this case,
Yes. Termination of service order.
madam. Minister
Section
4, page 142, yours. On the ground that matter.
Just 1 minute.
Madam.
1 minute. Yes. Yes, so they have terminated your contract.
My lord, during the pendency of the period,
Now, what was the duration? What was the duration of your contract?
my 3 years, the contract start on 23/6/23,
Yes.
26/23, 3 years, your lordship, page 33, your lordship must see, relevant page. Contract, period of engagement, your lordship see. The agreement, your lordship got it. The engagement shall be for a period of 3 years from the date of actual apportion.
I can't hear you, sir. You are saying I can't hear you. Which page you are referring?
Page 33, your lordship. Page
Page
33, 33, your lordship.
33.
My lord. Page 33, your lordship. 4.1, your lordship may see. Period of engagement, your lordship. Okay. Period of engagement. The engagement shall be for a period of 3 years from the date of actual operation of or signing of the contract, whichever is later.
Yes. Where is the termination clause?
Termination clause, your lordship, 4.8, your lordship.
Page 69.
Page
69. Clause 8.
But that is something
Yes,
else.
yes. 4.8.
He was referring page. This is
For your 38, page 38, page 38, your lordship. Page 38. Page 38, your lordship.
yes.
Page 38, lordship, termination, 4.8. Termination. My lord, termination, it says the district authority institution may by notice of writing suspended the contract with the selected agency fails to perform any of the obligation, including carrying out the service.
Nothing is audible.
Sir, you are not audible at all. I think either there is some internet connectivity problem. Your voice is not coming.
My lord. Am I audible now, my lord?
Now you are.
My lord. You know, see, here it is
Again, you are not. Sir, once you are closer to your mic, it is all right. The moment you go out or far, we are not hearing you.
Okay. My lord, here only 4.8, my lord, I'm drawing the attention. Here it is categorically said.
Sir, sometimes.
Am I audible now? Am I audible now?
I think the bandwidth has to be increased from your end.
Your lordship, audible now?
Yes.
My lord. In this case, my lord, the 4.8 specifically said that 30 days notice has to be given. Your lordship, see for subpara 2, the district authority institution, after giving 30 days notice, clear notice in writing, expressing the intention of termination by stating the grounds on the happening of any event of the events, may terminate the agreement after giving reasonable opportunity of being heard to the services of the petition.
Correct.
In the instant case, my lord, neither 30 days notice has been given.
So what is the date of the notice? What is the date of the notice at 142?
Date of notice is?
Yes, you have been given a 30 days time.
Yes, 9/4. No notice, my lord. 30-day notice has not been given at all.
So you are given a 30 days, more than 30 days time to complete the work.
No, my lord, nothing of that sort. No notice, a fresh tender was floated. And against that fresh tender, I have filed another writ petition, my lord. That is pending before your lordship. While the pendency of the writ petition, they might terminate.
Have you obtained any order of stay in your writ petition?
And the stay or earlier case, earlier case, no stage was granted, notice was issued.
So where is the difficulty on their part to proceed?
My lord. True, my lord. Then now the termination.
They have
also-
said that there was several reminders to you to redress
My lord.
the difficulty or the deficiency,
My lord.
but you have not done anything.
No,
And
no,
ultimately being perplexed what they will do. And this
My lord.
relates to a security.
My lord, in this instant case, no notice at us has been given. That is my plea. No notice, not a scrap of paper has been given. The 30 days notice that is mandatory as per the RPF has never been.
Who is you are appearing because you are. Why? May show us the 30 days notice, which is
Page 142, my lord, annexed four.
it is like if I say Alice in the Wonderland, the situation. The Charles Dickens Alice in the Wonderland is the same thing. Where the king said that behead him first, then the trial will begin. So what the trial will do after he is beheaded, you have done the same thing. Terminated without giving any notice. What he will do?
This is the notice, my lord.
Is a
We have given
notice.
1 month time. 9/4/25, we have given the notice.
Sir,
Termination
notice.
takes effect from 15/5/2025, my lord. Page 142.
Sir, this is, have you seen the second paragraph of your clause 4.8?
Yes, ma'am.
It says that after giving 30 days clear notice in writing, expressing the intention of termination by stating the ground or grounds
Yes,
on the
ma'am.
happening of any of the event
But ground we
as
have
mentioned
stated
below. As mentioned below. Please
Note, ground.
read one word, every word with some precision.
Yes, ma'am.
So, first thing is 30 days notice, clear notice. Intention to terminate must be there. And you should also indicate the grounds. And what are the grounds? As mentioned below. So, we have to go below. May terminate the agreement after giving reasonable opportunity of being heard to the service provider. Where is the opportunity of being heard?
Yes, ma'am.
Then what are the grounds? One is if the service provider do not remedy a failure in the performance of his obligation within 15 days of the receipt of the notice or within further period as has subsequently approved in writing, then you'll have to give 30 days notice.
Yes, ma'am.
2. Is service provider insolvent? He is not. 3. The result of force majeure? It is not. Then in the judgment, the service provider is engaged in a corrupt and fraudulent practice. This is also not. Your ground as I quote that he was instructed several times to remedy the deficiency which you perceived in the service. He has not done so.
We have shared in this notice as per clause 4.8 of RPF article gender advision so and so, that is 11/1/23, your agency is not able to fulfill the conditionality attached with the letter of award completely till date after gentle reminder through several review meetings and letters.
So this 30 days notice.
Because to ask that purpose, my lord.
Then if you have said that you are taking a plea of 1, that is a numerical number 1. You are taking shelter. Then 30 days notice that you appear, give your explanation why I should not be terminated.
Yes, ma'am.
The reasonable opportunity of being heard, can you whittle down? Can you completely erase? Can you do it? Tell us. Is it not a violation of a ordi ultra partem rule? You have ingrained, you have included, you have not. How can it be sustained?
Page 11, your lordship, see,
He has not given a no.
Different review metrics were held, assessing that performance of time to time and to detect the deficiencies. Page 11 may say this is
Sir,
the procedural performance.
probably, please try to understand what troubles me. What you are saying is absolutely correct. And this comes under this numerical number 1 of 4.8. Come,
Yes, ma'am.
please come. What you say is correct. What it says 4.8, clause 4.8, please come.
Yes, ma'am.
1. If. Have you got that 4.8?
Yes, sir.
Page 38.
Yes, ma'am.
Yes. 1. If. What it says?
If the service provider do not remedy a failure in the performance of his obligation within 15 days
Yes.
of receipt of notice or within such further period, as the district authority or institution have subsequently approved in writing.
Correct. So your ground is several letters were there. He has not remedied the failure in performance. Correct. You
Yes.
can.
Yes.
But these are the illustrations or the grounds on which you can terminate. How you can terminate? Giving a 30 days notice and inviting him to give a reasonable opportunity with the explanation, give an opportunity of hearing. Thereafter, you will terminate. Here you have straight away terminated.
Yes, ma'am.
Can you? This is what is the only thing.
Yes, yes, ma'am.
I understand your lordship's mind, my lord. And your lordship-
New incumbent. Understood.
I'll tell you, my lord, just two
New
facts.
incumbent.
My lord, I'll just tell you, my lord, two facts.
No facts. This is apparent.
I
And one of the
completely
open and shut case that does not require any kind of a.
I can't better it, my lord. May your lordship just give me just 2 minutes of indulgence, my lord. Well, let me just, if your lordship allows me just
Yes.
by the clock, my lord. Well, there's two things. My lord, may kindly have the review meeting thing.
Please tell me about this.
I mean,
I understood.
I'm not arguing for the state.
Every bit of the action of the petitioner is
I completely, I've already.
not in tune with the spirit of the agreement.
Your lordship,
Let us
views
go
are
to
loud and
that
clear, my
extreme
lord.
case.
Your lordship,
He has
views are loud and clear.
violated every clauses of the agreement.
Well,
Does it mean when you have incorporated, they have incorporated 4.8? Can it be done in this fashion?
I just want
That's
to
the only
bring
case.
two notes, my lord. This is a all Odisha thing which has been happening, my lord, across the state. My lord, what has happened? There's a policy change. My lord, may kindly have that. That may not override this. I'm just bringing to your lordship. My lord, may kindly have. My lord, may kindly have my IE, my lord, for intervention. My lord, what has happened? My lord has already seen it. My lord. I am the subsequent thing.
The moment you say it, I immediately understood.
My lord, made my job easier.
Yes.
My lord, my point is I've already paid the money. I have already deployed. While agreement was signed by me, work order was given. Post that without making me a party and stay order was obtained. So, my lord, being a necessary party, I was not allowed. I was never even given a chance.
Yes.
Now, my lord, that thing I'm still agreed by, my lord. Because as your lordship posed the question, did you get a stay? The answer was no. They didn't get a stay of the subsequent tender, my lord. Subsequent tender was floated after the policy change. I participated. I became, my lord, the L1. I have been given an agreement. Money has been deposited by me. Agreement has been signed by me. I have been asked to deploy. I have deployed. No, my lord, now I'm neither here nor there, my lord.
142.
If I may pray, my lord, for your lordship, my lord, if your lordship takes up 13377, my lord, I'm there in both. The first writ and the third writ.
What is this stay? We are not. I was thinking as if you are arguing as a writ appeal, but it is a writ petition. They are challenging that the 142 notice. Now, if we have to consider 142 notice, whether it can be sustained in view of this clause 4.8. That's all. If it cannot be sustained, cannot be sustained. if anything wrong has been done, does it create any
That's why my hands are
right
tied,
to
sir.
you
My hands are
or a
tied, sir. As an
statutory
officer of
right
the court,
to you? You can ask for a compulsory, no advisory jurisdiction
completely
to
bottom.
be exercised. You take your recourse to law, let them. But if termination goes, it goes. And which is contrary to the
it I'm not able to see. But only just look at the policy decision and the review meeting.
whatever
That's the only thing.
can it override a substantive contract?
That's
a concluded contract.
no, that's
Unilaterally, can you vary any terms of the contract? Can you modify the contract?
that's
Can you do it unilaterally? It's a bilateral contract. You can't vary the terms of the contract unilaterally.
The only thing is in their agreement that they were signed, the agreement, my lord, are looking at the terms and conditions of the tender. The agreement which has been signed, it says the agency will be engaged initially for a period of 3 years, subject to satisfied performance. I'm completely bored on what falls from your lordship. That if he did not follow, please give him 30 days notice and terminate.
They have taken a shelter under clause 4.8. 142 talks and reflects 4.8.
Para 3.
In fact, my lord, if I only assist your lordship, that's 4.8 of the tender. The agreement is at page 62, my lord.
No, we need
No,
not.
no, it is-
We need not because 142. You take
Please
Take up
look at page 142.
No, I agree.
The termination order which is under challenge, the authorities have indicated 4.08 that I invoke this provision of termination here now.
4.8
Of the
of
tender condition.
R.
Of the tender condition.
They have not gone into that agreement.
Well, I agree. That was a concluded agreement, but they have not.
Sir, once the tender is accepted, it becomes a concluded contract.
Even if, after
I
that,
did
they have
not
not
have
signed
to
an
go into that first principles of contract. So this cannot. You can initiate. There is no difficulty. You can, but the manner in which it is done, the challenge is made to a letter number 4490/.
provided in the contract also, the if it can be treated a dispute, district level committee can also consider that.
It was a fair case, the notice would have
Yes,
been
ma'am.
that giving you 30 days
Ma'am.
time, come and explain that why we will not terminate your contract.
Yes, ma'am.
It does not terminate, there is no difficulty of.
May I humbly frame my appearance for opposite party number 3?
We not recorded.
Opposite party number 3 finally recorded.
Oh, recorded. I heard not recorded.
Connected rate application.
What is this?
Lordship, connected rate application, Lordship, second item.
What is a connected repetition?
Second rate application, Lordship, that is second
What
item.
remained? The termination goes, then what remained?
But Lordship, all are different matters, Lordship, the different to different establishment, Lordship.
No, different. This is a different.
Different, Lordship, not to, but the law remains maybe same, Lordship, but different matters, Lordship, different establishment, Lordship. Here, Lordship, to enhance, Lordship.
This was the case of which district that was?
Ahmedabad. The first case is Ahmedabad.
And this is?
Angul, Lordship, Angul list, just.
This is Angul.
Angul, Lordship.
I'm not there in the second one.
Okay, Angul.
And the first matter was Kandamar, as your lordship said, housekeeping. The issue was housekeeping. The third matter, the third connected matter is Kandamar, but it is security matter for the issue of security. The first was housekeeping Kandamar, the third is security of Kandamar. And on the
Same letter.
same letter, 9/4/2025, same thing.
Same letter, same matters.
Same
What
thing.
to do?
But second is something different. It is a particular government policy that is normal.
Third item.
Third item, same.
First
Same
issue
item.
is the same.
Similar.
The clauses are the same.
For the reason stated, say notice to the actions, questions that said with the direction. Then
Now, this matter is a security service matter.
Lordship. The second is housekeeping, but Lordship, pertaining to government policy that is normal. And here, Lordship, to enhance the facility, Lordship, the service, they have done this. Can it be segregated, Lordship? I will file a rejoinder that it can be had, Lordship.
And who are you?
Lordship, I am the successful bidder, Lordship. I am continuing there, Lordship.
No, sir. No, sir. What is your right? Nothing.
No, I am continuing there, Lordship.
Can a contract we have had, it cannot be varied nor can be whittled down by a unilateral act of the parties.
Parties, Lordship, they have done it, Lordship.
Maybe,
In
but
my
it
case,
cannot override the subsisting contract. Sorry.
Lordship. Here is, Lordship, I have a subsisting contract, Lordship. I have subsisting contract, Lordship.
It has to go, sir.
No,
It has to go.
no, there is a contract with me, Lordship. I have the subsisting
Maybe,
contract.
there is also a contract with him. He is appearing. No,
No,
sir.
no.
No right.
Lordship,
No right.
Lordship, I am continuing, Lordship.
Yes, yes.
My
No right.
license, my contract up to 2026, Lordship.
Yes, yes. Sir, your contract is terminated.
But it has been stayed by your Lordship's order, Lordship.
I do not know state or what.
Second case,
We are
Lordship. Second
setting
case.
aside this order. Why you are standing in the way? We are setting aside this order.
My case something different, Lordship.
What?
Lordship. So can I, Lordship, I can develop my case, Lordship, because
4.8
they have filed a counter.
clause is the same clause. 4.8
No,
is the
Lordship,
same clause.
here they have reached, Lordship, can you see what they have assigned in the region, Lordship?
You are
My
for
case,
whom?
Lordship.
You are for whom?
Second case, Lordship. Second case, Lordship. That is
second
Manju's
case, petitioner.
petitioner, Lordship. I am for the petitioner, Lordship.
Sir, we are setting aside the order of termination. What you want?
Lordship, but some.
You want a stay. You do not want a termination. The setting aside of this termination order.
So giving them right to.
We have caused and set aside this order of termination. What more?
No, what is the peculiarity in your case?
Lordship, my case, Lordship, pertaining to a government policy that is called Nirmal, Lordship. And person that policy, Lordship, I was the successful bidder and I was continuing. And Lordship, to change the policy because to give the better service, anticipating a better service, Lordship, they come up with this.
No, they segregate. Then if he does not want, we were passing an order in his favor. He does not want.
No,
Segregate
Lordship,
it,
no.
let it come on 1st of September. Yes. Segregate this, come on 1st of September.
Item 27.
This matter.
Interim order to continue, Lordship.
No.
Interim order.
We don't know interim order is there or not. If it is there.
That is there, Lordship. Interim order there, Lordship.
Item 27.
Okay, sir, may I please? This is for
Yes,
amendment.
in a site order, but it's still.
Then Lordship,
Sorry.
I will have the same order, Lordship.
No, no.
Lordship,
No.
Lordship, first same order, I don't mind, Lordship.
Mr.
Lordship,
Dale,
first same order.
it will be placed on first commander.
Lordship, interim order to continue that then, Lordship.
It is there, then.
Yes, Lordship, that is there, Lordship.
Item 27.
This is for amendment, ma'am. An amended application.
What is that number, sir?
13333.
What do you want to incorporate, sir?
Malad, what has happened, Malad? I have challenged the order dated Malad 5/2022, where Malad, even though there was no stay by this, I am a leaseholder, man. Even though there was no stay, the earlier writ application has been tagged. By the letter of the government, the Advocate General Office issued a letter that since the case is pending, you stop his operation. Even though there was.
How can they issue a letter?
That is under challenge, man. Now, since Malad, the earlier writ application that was pending, because that was many times heard and judgment was reserved, that is why the earlier counsel did not file the writ application. Even though I have instructed him. This court, Malad, while issuing the notice.
So instruction was not followed. You say even I instructed him. I say your instructions are not followed.
That is why this honorable court, your lordship has said that you explain the delay in a better manner. That is the Malad.
You wanted to incorporate.
Exactly.
You file your counter. If there are any materials available to you that these statements are not factually correct.
The amendment may be allowed. I'll sorry, may Malad consolidate this application.
And in the meantime, he will file the opposition also. That means the counter as well.
Yes, fine.
Lord, I need to file the counter for the amended writ petition.
Yes.
Amended. That's why one composite.
Yes.
The amendment is to be allowed.
I'll file it by consolidated. I'll file it by tomorrow.
Your amendment application is 13333.
13333.
I have 13333 of 2024.
What is the connected matter? Please do that, sir.
28.
Yes.
With regard to this matter is next matter. If an interested girl, but today she is not there with us. It's a very big. So may I say we got a short date? In fact, tomorrow we'll also do.
I'm not standing in your way. In fact, Your Lordship, on 22nd last month, the Lordship directed the State Government Council, they obtained instructions, they'll be obtaining instructions after filing of my regional directive. Thereafter, after receiving the memo which I filed on record, Your Lordship at flag 30, they started proceeding with the tender process by fixing a date. Thereafter, Your Lordship may faintly recollect that I moved Your Lordship orally, and Your Lordship directed them to hold up that entire process. Now then, since they are proceeding, there is no interim order and they are proceeding. I have filed an IA application for the purpose of consideration.
Come tomorrow.
No, Milord, that has been, I don't think they are proceeding, Milord. We have informed.
That's what I said. That's what I said.
We have informed them and they are not
Since they were
proceeding.
proceeding, I had
They
filed
are not proceeding.
They were not, that's what I said, my lord. Since they are not proceeding, but in the meantime, I have already filed an IA application learning that they are proceeding, and I mentioned before, Lordship.
Don't press that. Come tomorrow.
Yes.
She's available.
In fact, I am thankful to the State Council that they have intimated the authorities and they have not proceeded.
Yes.
Item 29. Item 29.
It's not delay.
Service objection.
Objection, they have filed. I will reply to them.
But sir,
How much delay?
228. 228.
Let them file a rejoinder. What can be?
I should have delayed, Lordship may condone us here the matter. I have filed no doubt objection. If the matter is hard and very
198 days delay.
You see, they have written that 228. From that,
Ah,
I will say.
228 is total period occupied. Minus
copy
30,
period
minus
is-
30, 198 days delay.
Otherwise, it will be unnecessary delay.
Yes. When, what is the nature of the appeal?
Nature of the appeal is very short. That following the 2015 rules, the recruitment was held, advertisement were made, and they were appointed as the pharmacists. They were posted. So after 17 months, what happened? Well, the 2019 rule came. A paper publication came newspaper. That in that there has been mass corruption, bribing, all these things. So what the additional secretary did?
But that was in 2019 one, the corruption. Or in respect of this 2015.
In respect of this.
Yes, okay.
So
Scrapped everything.
They scrapped everything, saying that because of this allegation has been made in the newspaper, so you terminate. Then the CDMO terminated them. And the fact is that, well, here the principle of change of rule of game. Because 15 recruitment commenced and the appointment somehow was delayed, and then that was given in 2020. That time 19 rule had.
The corruption is the bigger issue. It does not.
Nowhere that, no, because your worship may inform.
Very high power committee was constituted, it was looking into that. Any trace or any clue or any kind of evidence
Nothing.
found about the corruption.
Only inference your worship can draw that those who are not selected, they might have been the instrumental in making such a news. And well, it is a shocking thing that is the additional secretary, higher rank of officer, is referring to that in the newspaper. This has come, so you turn. That document is there in the writings. And once the recruitment begins with the 15 recruitment rules, how can I refer saying that 19 rule has come, so that was done? So already the process began and concluded. So that is the only point.
So we are fixing this matter for hearing when.
Any date, 1 week after. Any date, 1 week after. Because next week is hardly 2 days. So exactly 2 days.
We can't be more working was there, but you people have.
Second of September.
I think 2 or 3 matters have been fixed on second. So.
Whatever convenient to allow.
10th.
Yes.
Item 30.
Delay first time or you are for the cooperating? Delay control or not? No. Service is affected or not?
That I am appealing for respondent number 4. She has already been superannuated,
Okay.
retired from servicing.
For the service of the copy of the condonation application has been done.
So I have, let me answer.
This is the first time it is coming.
Yeah, I have submitted IA. So there are two IA. One is 605 2025, where there was I prepared for dispensation of from certified submission.
I understand, sir, but there is the condonation, there is the delay, delay accrued a right into a certain, the other side. So he is to be noticed, he has to be, to issue a notice. Notice, if you waive the service, you can accept that notice.
Yes, ma'am. Yes, ma'am. I am
You
accepting.
are waiving the service.
Yes, ma'am.
So give him a copy, give her a copy. Here, you are for the writ petitioner.
No. I was there also respondent number 4. Yes, ma'am.
I am the writ petitioner.
Okay.
Not,
You were respondent number 4 there.
yes,
Okay, give him a copy.
may I submit something? A similar kind of writ appeal has already been disposed of. Only difference was there was a criminal proceeding, and here only the non-payment of loan. Because of non-payment of loan, her gratuity has been applied.
Let me consider first you take the application for condemnation. Would you like to go through? Or we dispose of? How many days delay?
It is.
Yes, delay may be on. Delay may be on.
44 days.
Yes, it's delay the road. Fix a matter of 4.
Right.
Come on, 4.
Congratulations.
Item 31.
Dispose of the main matter.
Yes.
31.
On this connected date, there are 16 days delay. 16 days delay.
I am appealing for the, except the first case, my lords. It is 7 cases I am appealing, my lords.
You are appealing for all the respondents?
Yes, my lords. Except the first case, my lords.
So it's the first case, the notice has to go.
But the similar.
Lord, may I just, what my friend is saying that, Lord, these writ appeals were filed in the year 2025. And there are 30 more writ appeals were filed in the year 2024. The coordinate bench has already dismissed those writ appeals. And insofar as the other employees
What remains?
therefore that order may be passed.
So we are dismissing all your appeal.
No, except the first one, what he is saying, Lord, that except the first.
The first one means he says I am not appearing for
The first one.
respondent in the first matter. But he is appearing. If we are dismissing an appeal at the threshold, then we do not have to give a notice. We are dismissing your appeal.
Similar order may be passed.
So this judgment, does your appeal in first case survive?
No.
Then,
So it has to go. So we are dismissing all the appeals.
why should we bother respondent to come?
Because they are all similar situations.
So.
That holder connected.
Yes.
Right. Yes. Item 32.
Yes, eligible. They are working for last 25.
Then separate copy that. ସବୁ ଜାଗା ନେଇ ଆସ।
In item number 32, my lord, there are 12 writ appeals, my lord. Last occasion, your lordship has. Yes, my lord.
All 12.
Last occasion, your lordship has condoned the delay.
Because we are not party to the writ petition, my lord. We have.
We has to, then they.
There is objection.
Yes.
That
Have they
only
filed
one,
after?
yes, they are part. Only one grant,
File rejoinder or no?
no, my lord, not necessary.
Not necessary.
Because of the fact that they have raised only one point, that the vendor of mine, my lord, all the appeals have no right to transfer the property in our favor.
So definitely,
That, my lord, I have prepared a debt chart
so that is.
to show that.
The legal principle is nemo dat.
Yes, my lord. To show to your lordship that they have the subsisting title over the property, which was taken away after 12 years of the settlement made in our in favor of our vendor.
By way of adverse position.
No, my lord.
Huh?
My lord, in a VPA proceeding, my lord, village fitting, in a village abolition act. Under that act, a Bebondabasta case was initiated. We have filed an application for settlement because of the fact that we have purchased my vendor have purchased the land before the act came into force.
From the admitted owner.
From the service tenure, my lord. Sir, therefore, from 8 acres and some land, 3 acres of land is settled in our favor. And rest of the property may be settled with the service tenure. That settlement was made in 1990. And my lord, we have paid the entire rent, all the government fees the vendor has paid. After the settlement, in 1993-94, sale deeds.
Patta was issued.
Yes.
Patta was issued.
Yes, that is Annexure 1. In favor of our vendor, man. In 92-93, 93-94, the property was sold to us. 90, my lord, the settlement. 93-94, the property was sold. And thereafter, my lord, one of the interested party in whose name the land has not been settled, some land, he has preferred an appeal. They was the appeal. In 1997, some property was settled in his name. Challenging the settlement made in 1990 and 1997, they have preferred revision before the Board of Revenue under Section 38A, including the vendor as the opposite party, vendor of the appellants. In the revision, it was pleaded that since the land has already been sold and they have not been, the purchasers have not been made.
Because they have no subsisting right as on that day. Because the land has already been sold.
Yes.
So the vendor has no subsisting right.
Therefore, the revision petition is bad for non-joinder of necessary party. What the revisional authority?
Misjoinder of necessary.
Non-joinder, that has been written.
Yes.
The revisional court does not take note of that. And finally, the settlement made in favor of all the parties was first. And it was directed to death of the land in the name of the government. Government. In 2005.
Patta goes, yes. Patta goes.
Yes, ma'am. In 2005. That order was passed in 2005.
Then what you did?
That's why I am saying 90s
Then
settlement.
what you did?
I have no knowledge. I have never been my party. In none of the.
Now you are challenging when you came to the red court. You came to the red court.
No.
I think. By virtue of this order, everything goes or what?
No. I am submitting them.
So the revisional court or the revisional authority quashed the pattas. Then what happened?
Then, my lord,
we wanted to
the respondent number 4, in whose name 40% land was settled, 50% land was settled, he preferred the petition before this honorable court, challenging the revisional court order.
Correct.
They are also married. I have never made me.
Correct.
They have not made us party.
Then what happened to the rate?
In that read, in 2008, this honorable court while my lord confirming the order of the commissioner, have granted liberty to the petitioner, in that case, the respondent number 4, to file an application under section 5 of the BPA Act, my lord, for settlement. That was filed in 2008. There also we have not made parties. And in 2010, the entire property was settled in favor of the respondent number 4. That was also not within our knowledge.
Even your portion.
Yes. And thereafter, my lord, after it was recorded, entire land recorded in favor of the respondent number 4, he has filed an application under the Service Settlement Act to record the entire land in his name.
What?
My lord, after it was settled on the BPA proceeding, which we do not know what happened to that. It was directed to record the entire land in favor of the respondent number 4.
Correct.
Thereafter, respondent number 4 filed an application on section 15B of the Odisha Survey Settlement Act to record the entire land and issue ROR in his favor.
Oh. Means he wanted his name to be recorded in the record of rights.
Right. That was dismissed.
Dismissed.
Yes. Against which again they have filed a writ application before this honorable court. There also we have not made parties. We have after purchase the record of rights for in a mutation proceeding, all have been recorded the land in our favor. In the survey settlement proceeding also we have never made parties. This honorable court, while disposing the writ application, set aside the order of the commissioner and directed, since the land has been directed to be settled in the BPA proceeding, he has no authority to bypass that order, my lord, because that is a proceeding of title. It is only, my lord, going to record. In spite of that, there is no recording. Again, they have filed a writ petition. And there was a direct order to record the land in their name. When they came to dispose us, to demolish our building, well, last 30 years, my lord, since 1993, we are possessing that land, constructed our house.
Then you come to know that all this thing has happened.
Thereafter, my lord, I have filed the writ application.
So what order is challenged here? In which order? The last order.
Last order.
Directing the recording of the name.
Without notice, without anything, my lord, direct to record the land in the name of respondent number 4, without following the procedure as for Odisha Road Survey and Settlement Act. We have the recorded pendant, my lord.
Madam, the difficulty is that all those orders are staring at.
My lord, yes, my lord, my lord, now I am taking steps to file an intervention petition in those cases.
Dispose of matter. Yes. Intervention.
No, that has been today. It was listed today. The purchasers had filed a petition to recall that judgment because they are challenging the subsequent judgment, the original judgment which was passed, confirming the settlement, that they had not challenged. I had raised that point, so that today they have filed a petition to recall that judgment and also to for interveners. So another learned counsel had filed in court number 23. He did not press that. He has not pressed. Rejected. Dismissed as withdrawn.
That is, my lord, in relation to Survey Settlement Act.
No.
Not BPA.
No. The present judgment which is under challenge is a judgment to implement is a sequel to the earlier judgment of this honorable court. The earlier judgment that they challenged means said that let it be recalled. That has been rejected.
That should have been rejected. Because that is a proceeding under the Survey Settlement Act. Unless the BPA proceeding is challenged.
That BPA proceeding,
Give me a short.
Yes, man, I have brought.
Lord,
I have brought.
Lord, may
Relevant provision of the act. Let us see.
The only date chart I have prepared.
Relevant provision of the act. That
BPA Act.
yeah, VPA under what provision it lies before the revisional, because I am well versed with the
Local law.
another adjoining state.
more or less, more or less.
State Acquisition Act is known to me, then the Land Reforms Act is known to me. That
More or
is
less.
no. But here, give me that act so that I will have the.
Lord,
act.
may I suggest something subject to your lordship? Lord, here there are 3 petitions filed. Appeals have been filed, 3 petitions filed. One for condonation of delay, which your
What is
lordship.
the leave to appeal?
Yes, I'm sorry. The second is injunction, which your lordship have passed the interim injunction. Third is the leave. Lord, may I suggest one thing, Lord? He wants to argue. They want to argue the case on merits. Lord, I am.
Let the leave application be allowed.
Yes,
Leave.
and the case be fixed. I am filing. I have served the copies of the.
And you should also remember
Right.
that we are recording your name in a recorder right.
Doesn't
not
create.
mean
No, I have got a substantive right.
any title is created in you. If you want to evict a person who is in settled position, then you'll have to go under section 5 of the Specific Living Act.
Lord,
You
that
have to seek for
that question will not arise. Lord, what I am saying. But I will.
Cannot be done in this way.
But your lordship may kindly fix the main case for hearing, and where I have.
Give me that list of dates. Oh, sorry, the date chart.
Right.
I am ready with my counter affidavit. I am filing it today. In the main case. In the main case.
This is an application.
September.
Like interim order. All the cases there are interim orders.
Not interim.
not to status quo.
It appears from the permission.
In the location I have moved and interim order was passed.
Why?
That
Interim order was passed, status quo order was passed, right? Status quo order was passed. That order may continue. I don't have any objection. But to say that I am not in, what I am saying, by the time 2008 judgment was passed,
And unless they have threatened my possession, why are you trying to return when I have not made party to the entire proceeding?
What is troubling me in the judgment of the Supreme Court issued with this 2006, volume 3 or 4.
Justice Bal Subramanian. The status quo is
Status quo in respect of a possession without identifying who is in possession.
yes, yes.
Is the most dangerous order. The Supreme
There's a
Court
decision
has
of
clearly said. So that's why I stopped the moment he says. When a position is in dispute, then one has to
and if
do one thing, madam.
if he will
Do
show,
one thing. When he is saying so, no difficulty.
I will find all the decisions.
We are appointing an advocate as a special officer who will go and find that who is there in position.
Yes,
No difficulty.
no difficulty.
Yes.
I agree to that. We have constructed the house. We are living there.
Yes, sir.
Lord, I am interested in final disposal of the case because what I am saying, by the time 2008, the judgment was passed by the Honorable Court, Division Bench of the Honorable Court. The vendors were very much parties and they suffered the decision.
Which place?
Burla.
How far?
About 300 kilometers.
Any
And I will pay the cost, Mela, of that advocate.
any advocate of that locality?
A little delay the matter, your lordship, because
he will go immediately.
Lord,
Don't worry. Because she will ask for a 10 days time to rejoinder.
Yes.
In the meantime, it will come.
but that is what I am saying. The meantime, it doesn't come to measure such a big portion of
Not sir, every house is there.
One day the report would be filed.
Yes,
During the weekend it will go.
yes. I am totally agree to that. Any of the
I
house.
have also no objection. Pardon, Lord?
There is anybody who has.
Guru.
No, Mr. Guru is
He's
appearing with the appellant, for the appellant. He was in the other case.
Then no.
He was in the other case.
Any other person.
He belongs to that area that size. Or at least he's from Balani.
my lord.
He's from Balangir.
Balani.
Mr. HS.
Ashish Mishra. Ashish Mishra.
Mr. Ashish Mishra can.
Anybody of that locality?
Ashish Mishra is from Bolani.
So it is in Balangir.
Near Neighbor district. Sambalpur, Balangir. And I am ready to the ready for.
If he is there appearing for the party, I want anybody who has
New
no connection, who has no. Okay.
Your Lordship may pass the order not to change the nature and character of the case, not to create third parties.
By who?
By the appellate, both parties.
No difficulty?
Yes,
No difficulty. Yes.
not to create third party interest and not to change the nature and character.
Yes.
Then your lordship understood my lord, the fact
What?
that we are in possession. You will not make any third party
That
transfer.
implies, madam, why you are saying the moment he has accepted not to change the nature,
Yes.
who can change? The person who is in possession and control.
Let the appellate be.
Yes, same order in respect of our property.
My lord, in morning I mentioned, my lord.
Which matter?
My lord, item number 36 will be posted on 10th September, my lord. Item 54.
May be permitted to.
Will continue.
Till next day. Till next day.
Item 34.
Item 52, my 4 for withdrawal. Item 52, today morning I mentioned, my lord. Observe item I become 52.
A 52, 125 at the top.
Yes, ma'am.
Very particular. Well, I not the time column. 26.
Matter, tender matter, might solve me no difficulty.